Oh, good morning, good morning. Good morning, Jody. You're the only one with me so far. Gonna give everyone a little chance to trickle in here. I don't have
Glad you
anyone in
wanted to play.
the classroom with me, and you're the only one on Zoom.
Oh,
Let's see. Yes, I did send you a buyer scenario
yep.
for the contracts challenge. So if you have any questions about that, get with one of the coaches or with me.
Okay. Let's see.
It's a few minutes after 9, so I guess I'll just go ahead and get started. So since this is kind of an abbreviated week, oh, here we go, Amber.
I get,
Amber's with us too.
there we go. I was wondering if you could hear me because my volume wasn't
Good
working.
morning, Amber.
Are you
Took
able to
me a
hear me
couple of
now?
minutes to get on this morning because I'm trying to cast in the classroom too on the screen here in case anyone does show up here this morning, but and it was giving me some trouble, but it looks like maybe it's going to work now. So, all right. So Jody and Amber, and then all of you
Okay.
out in video land that might be watching this on the digital chalk. Yeah, Jody says good morning. No, I couldn't hear you.
Uh,
You were
okay.
talking.
You think can you hear me now or is the volume working?
Huh. That's weird. I don't see that you're muted, and I've got my volume turned up. We've been having kind of that trouble with Zoom lately. Not just in this room, so I think it might be a Zoom thing. So yes,
Hmm.
if anyone out there has anything to say, it's probably best to put it in chat or show me your face and wave at me or something. So okay, all right. Well, we're going to get started. Go ahead and get started this morning. This is the contracts class, and since it's kind of an abbreviated month because of the holiday that's coming up, the Thanksgiving holiday that's coming up. We're just that this would be typically the week that we do maybe some of the special documents or the addenda, that kind of thing. But we're going to jump right in with contracts. Today, we're going to talk about the contract, and then on Wednesday, the class will be on getting ready to write an offer. But talking about the contracts here today, and I think both of you had, Jody and Amber, the two that I'm seeing with me on Zoom this morning, have already attended this class. But I do try to make things a little bit different every time we talk about it. Oops. Just did myself no favors there. So we're going to jump right into that. I'm going to share screen here for my people on Zoom, my entire screen. Oh, I guess I'll go ahead and turn my phone off too. Oh, and I lost my cast in here. So don't know why that's going on. All right, and so y'all are seeing my dog there. That we're gonna, right? So can everyone see me? Give me a thumbs up emoji or something if you can see me. Oh, I've got another chat going on here. Okay, all right. So all right, and again, not a dot loop class. Both of you, I think, have had some experience. Jody and Amber have had some experience with dot loop, so nothing new there. But so this is what your loops will look like. And so I've pulled up both versions of the real estate sale contract. I've got the one with calculations and the one without calculations. For our purposes today, it doesn't really matter because we're not going to be doing anything with any of the numbers here. We're going to be talking about what's in the contract. So today, I don't think I've really gone over this in depth over the last few months. So I'm probably going to ask Jeg to post this one specifically on the digital chalk platform because today we're going to go about we're going to talk about the rights and responsibilities, rights and obligations of all of the parties in the contract, not so much about about filling it in. We're certainly not going to read the entire 16-page contract. I don't think that the 2 hours allotted to me here would allow for that. But we are going to hit on all of the paragraphs and what the paragraphs then obligate the parties to, or give rights to the parties. Because a deep understanding of our contract is imperative in what you do. When Kristen sent out her email about this class over the weekend, I think it was actually Friday when she did that. Maybe a couple of people coming in here this morning. Hey, yeah, contracts class. Yes, yes, yes. Good morning, good morning. I'm good, thanks. So a couple of people coming in. I've already, oh, and it is casting for me, so that's good too. Okay. Have I met everyone?
Daniel.
Daniel,
Yes,
okay,
how
all
are you?
right. I'm good, thanks. How are you?
Mhm.
Linda?
Linda.
Yes.
Cool.
Anna, or Anna, okay, I think it's what Megan calls you, so, yes, we did meet at Wednesday Night Warriors, didn't we? Okay, so I've got Anna and Daniel in here with me. Oh, good, it's always so much more fun when I have actual faces, because nobody on Zoom ever shows me their face, so I've got a couple of people joining us on Zoom here, so we're just getting started. And I was just kind of explaining what we're going to be going over today. As I was just starting to say, as Kristen sent out her email over the weekend, I did really appreciate the fact that the contract is the most important tool that you have to work with. All of the launch stuff, all of the lead generation stuff that you do, of course, that's very important for your business, but writing the contract is your job, and understanding the contract is your job. So today we're going to go kind of in depth in the rights and responsibilities that are established when a buyer and seller in our world sign a contract. And then on Wednesday, we'll go more in depth on what you need to do to prepare to write a contract, actually filling in the blanks, and a little bit of both today and Wednesday. We'll go into some of the negotiating tactics that you can use as you are writing offers and negotiating transactions between buyers and sellers. And from here, we are looking at it from the buyer's standpoint, that you'll be writing an offer representing a buyer. There's a little bit of a flip side to it when you are accepting an offer on behalf of, and presenting an offer to a seller. But today and Wednesday, it's mostly going to be about how we the perspective from the buyer, how we write the offer, and how we present things to our buyer. If I'm going to flip sides on that, I will let you know. So move everybody down here to the bottom. All right, and for those of you that are really, really new, if you've had any, so Daniel or Anna, have you had a chance to go on and play with dotloop? Are you getting kind of familiar with that? Okay, good. All right. This isn't a dotloop class, but I do like to show what, oh, excuse me, forgot to take my allergy pill this morning. What the loop would look like. And so here I've got my contract docs, and I'm using the residential real estate contract without, I think without calculations, but today it doesn't really matter. So as I said earlier, I do not ever expect anyone to memorize the contract. I don't even have the contract memorized necessarily. I think it's really, really, really important for you to be intimately familiar with the contract and what it says. It would be nothing, I don't think, any more embarrassing than a client or customer asking you about something that's in the contract, and you just kind of have to stare at them because you don't know the answer to that. So I think now I do have some cheat sheets for everyone. If you don't have one of my contract cheat sheets, Jody and Amber, I'm pretty sure you do, or anyone out there in video world. If you don't, I don't think either one of you in here in the classroom have asked me for that. I do have contract cheat sheets on what to write in the blanks and where to get the information from that. So if you need that, if you want that, send me an email and I will be happy to email that to you. All right, Daniel asked what my email is. contracts, CONTRACTS at KWINKC.com.
Okay, all right, I'm sorry. So you said about
Contracts
your,
coach at KWINKC.com. So just say, hey, Linda, please send me that contract cheat sheet. So filling in the blanks, but I would heartily suggest that you all come up with your own cheat sheet, either in addition to that one or on that one, where you can write out to the side of each paragraph what that paragraph deals with. There are so many things within our contract that, again, it's imperative for you to know. And there's absolutely nothing wrong with having that with you when you are talking with a client or customer or sitting with them. You know, rarely do we sit with our clients and customers to write out the contract anymore, but absolutely nothing wrong with that. In fact, I think that kind of gives you a strength that you don't want to be doing anything wrong as you're showing them. But all right, so before we even get into any of the numbered paragraphs, we have our header here, as we do in all of our contracts and all of our documents. But first point out here that this is the residential real estate sale contract. For those of you that are thinking about branching off into other sides of real estate, we do have commercial and we do have land that have their own contracts because they're their own special criteria within those. So if you do have those needs, come to me or to your coach, probably me, because I'm not sure that the coaches are necessarily really familiar with the commercial or land contracts, but come to me if you have those needs because it's not the same form. But all of the real estate contracts that we work with are all through the KCRAR forms, that template in your dot loop. And then also kind of a little helper up here on the screen, the gray triangle that you will see on some of the pages throughout the contract, and this only applies to residential. The residential form, land or commercial, does not have the gray triangles, but the gray triangles indicate that there's something on that page that you need to address. There are some pages that don't have the gray triangle that have some blanks that you can fill in, that you can alter, because all of our blanks have a default behind them. But the gray triangles indicate something that you need to address, that you have to address here. So still in our header, we have our buyer and seller. This is these are the two parties to the contract. We are not parties to the contract, but the buyer and seller are. Make sure that you are identifying both of them properly. It does say right here on the form in bold and underlined on line 1 to indicate the marital status of the parties. So AMC for a married couple, ASP for a single person. Both seller and buyer can be indicated as an entity such as a trust or a company. So make sure that you're also identifying that properly as well. If it's we don't typically see buyers buying in a trust, but we a lot of times see the seller selling as a trust. So make sure that you're using the correct and proper name for the trust. That could either be, what I like to do is tell you to look for that on the seller's disclosure that's in MLS. If it's because tax records are not always updated, especially when someone has gone from using their personal name to putting something in a trust or an LLC. But if there's not a seller's disclosure for you to pull that from, then contact the listing agent and see that you have been given the complete proper trust name or LLC name. So, and for our buyers, usually we're indicating marital status there. So be sure that you are indicating marital status. We do see LLCs purchasing property. So again, make sure that you are indicating that as well. We're still in the header here. We are indicating whether this is a bank-owned property, a foreclosure property. You will be given all kinds of hints and clues in the MLS sheet itself. If it's a foreclosed property, it will say it's somewhere within the remarks. that it's a foreclosure, or it will name the bank as the owner, or it will say it's FHA, VA, or USDA foreclosure. If you look in the ownership section, there's one of the fields on MLS is ownership. If you look there and it says REO, all of that indicates that it's a bank-owned property. You will have all kinds of indications of that. If it is in fact a foreclosed property, you will check the box on line 9, still there in the header. On line number 13, improvements on the property include a manufactured or mobile home, going way back to what you would have learned in your pre-license class. A mobile home may or may not be considered real property. If it is not permanently attached to the land, then the county that the real estate is in probably has not started indicating on its records that it is real estate. The reason that the question here in the box here is important for you to pay attention to, now not so much here in the suburban metro area, but when we are out in more rural areas, a mobile or manufactured home may still be considered personal property. If it's personal property, your buyer probably can't get a loan for the entire purchase. They might be able to get a chattel loan for the manufactured or mobile home, but this is my and or but here. And the lender will probably require that if they're going to do a chattel loan on the mobile or manufactured home, that the buyer already own the land outright. So that can become problematic for us. You will need to check with the county to see if that county has issued what is called a certificate of affixation, and if the property is regarded as personal property or real property. Again, not a concern for us when we're selling real estate here in the metro area, but more of a rural thing. Paragraph number 1, we are identifying the property. We're identifying if we are including any addenda and the legal descriptions and conditions of the purchase here. So paragraph number 1, we are going to identify the property using the property street address in here is perfectly okay on lines 20 through 23. Make sure you are indicating the county that the property's in, but we will also include, starting on line 27, the legal description of the property. You will find that on the tax records. It says on the tax records not to cut and paste that. It shouldn't be used as a legal description on any legal documents, but that's what we use anyway. From there, the title company can get the complete legal description. We are identifying the property here on the contract. The title company is the one that's going to insure the property, so they will have the complete one. Ours here is probably, I'm going to say probably good enough to identify the property for the title company to start all of their work. Still all here in paragraph 1, do like to start talking about lines 39 through 44. A really important thing for you to be doing before you ever sit down to write a contract is to take a really good look at the seller's disclosure. I suggest that you do that before you ever show the property. Send a copy of the seller's disclosure to the buyer before you go show the property, as you are deciding whether this is a property that the buyer really wants to see or not, because this might be one of those deciding factors. What shows up on the seller's disclosure as far as condition of the property, physical condition and title condition, and also what may or may not be included as conveying personal property in the contract. So what this paragraph here tells us is that whatever the seller put on the seller's disclosure is what governs what is being conveyed as far as personal property and the condition of the property. If anything changes, if we make any changes to that on the contract itself, on this document, then that overrides the seller's disclosure. But if we don't address anything on here, the seller's disclosure is the governing document. We have our pre-printed list here, starting on lines 46 through 51, of things that we do expect to convey with the property as real estate. It's this exact same list that is on page 7 of the seller's disclosure, exact same list that starts on, on page 6 of the seller's disclosure. Page 7 is our list of things that that are not included on this list. But I do like to go over this list when I'm talking with my fairly new or new launch agents here. Because these are things that if your buyer's giving buying indications as you are at the property, make sure that you are talking with them about these things. So any attached shelves, racks, and towel bars would stay with the property. Any attached lighting stays with the property. Attached floor covering, so obviously that does not include any area rugs or that kind of thing, entryway or area rugs, but any kind of the vinyl flooring, carpet, hardwoods, all of that stays with the property. Bathroom vanity mirrors, whether they are permanently attached or just hung on a nail. We don't want the buyer moving in without having a bathroom mirror in there. Any fencing, including the buried pet systems, the electronic systems for pets. All fireplace grates, screens, and glass doors. We're not talking about the handheld equipment there, but the equipment that protects the rest of the house from a fire that's in the fireplace. Any mounted entertainment brackets. If the seller wants to take their entertainment brackets with it, those are the brackets that are holding televisions on the wall. If the seller wants to take those brackets with them, that's fine, but they need to repair the wall. That's what really that is all about. Otherwise, we expect the brackets to stay. Any plumbing equipment or fixtures. I think most agents that have been in the business for any length of time have a story to tell about how they have purchased a faucet or a shower head because what the buyer saw when they saw the property, and even maybe through inspections and through their final walkthrough, is not the same fixture that the seller left when the seller moved out. So that's one of those areas where there's a lot of confusion. So I think most of us have purchased a plumbing fixture in our careers. Same thing with storm windows, doors, and screens. That's one of those things. I rarely actually blame a seller when those are missing from the property, because that's one of those things that a mover can pick up. Movers, if a seller's hired a mover, movers come in and move everything. And those are things that are usually stored in the garage or the basement, and a mover is just going to pick them up. Otherwise, we do expect all of the storm windows, doors, and screens to remain. I've certainly had to ask for those to be brought back to the property. And then another one that tends to take sellers by surprise, the window blinds, curtains, coverings, and window mounting components. If you are walking through the property and you see that with a buyer and you see that some of the curtains match some of the furniture that's in the property, or bedspreads or bed coverings, that kind of thing, check with the listing agent about all of that, and make sure that the seller understands that some curtains have to remain with the property. And so all of those, and again, I'm going to flip sides again, as you are working with sellers, as you are walking through the property, getting ready to list the property, and you see that kind of thing, or just make it a habit to ask the seller when you're in the property, are you planning on taking any of these window coverings with you? If so, take them down now before I even have photos taken of the property, and go to Walmart or Target and replace them with something. We don't want the buyer to see something like that, because it is here on the contract and it's also on the seller's disclosure. We don't want the buyer seeing something that then you, seller, take away from them. Okay, now I'm back to the buyer side. I do like to point out that everyone initials all pages. When I mean everyone, I mean the buyers and the sellers. Again, we are not parties to the contract. So as you're writing the contract with the buyer or sending it to them, because of course you are discussing the contract with the buyer, even if you send that to them, make sure to remind them to initial every page. As you are working with this through .loop, I think it's best practice to go ahead and assign their initials to the bottom of the page. That way we don't miss that as things are going through. We're still in the through paragraph 1C, we're still in paragraph 1, but here we are still talking about things that remain with the property or if we change it, however it's indicated on the seller's disclosure, or any change that we make here, and this is our place to make changes. In paragraph 1B, starting on line 58, these are things that the seller said are not conveying with the property that our buyer wants to convey with the property. And my caveat here is, don't fill in this paragraph. Don't fill in this blank here. There are certain things that we've kind of gotten used to, but remember, the top of our document tells us this is a real estate contract. This is not a personal property contract. And so lenders don't like to see things on that we're including as personal property. So, and it's not a contract. It's not really for us to do. Yes, Anna.
Saying that, if you did fill it out, you could fill out like the washer with.
I'm getting there. Yeah. Okay. So don't be putting a lot of stuff in here. The things that we have, and I still don't like to use the word acceptable, but things that we do, that do find their way into our contract. Again, try to talk your buyer out of it, because, but I'm kind of jumping around here. So refrigerator is a common one, washer and dryer. Please don't go any further than that. Please don't go any further than refrigerator, washer, and dryer. You're going to have a problem with the lender, and you don't want something that happens with the personal property to squirrel your real estate deal. And I've seen it happen many, many, many times. So just be careful what you're putting in here. And if you are going to include those things, if they're already on the seller's disclosure, don't put them in the contract. That is the indication that the seller is going to be conveying them. One thing that I would do, if the seller says, yes, they're leaving the refrigerator, then you might identify that refrigerator by model number and serial number. But certainly do that if you are asking for the refrigerator to remain with the property. Because especially if you're asking for it and you just say refrigerator to remain with the property, that really kind of leaves the seller open to putting any refrigerator in that kitchen. And I've certainly seen that happen as well. So identify the one that you want to stay. I guess do the same thing with the washer and dryer. But please do not include riding lawnmower, dining room set, entertainment center. No, because here's the problem with that. Yes, Anna.
That's where you put the model and.
In the blank, right, yes, and the blank, I don't like to see things on line 57, but on line, starting in line 58. Start there is my preference. Okay, all right. Yes, that's where you identify it. Yes, a refrigerator, and then identify model number, serial number to remain with the property or to convey with property. So make that really clear. We also want to add the verbiage, because this, again, from your lender's perspective, we want to add the verbiage as being left as a convenience and has no value. Because the reason that the lenders don't like to see it is because if you start putting personal property in here, the appraiser on the property gets a copy of the contract. And if they see a lot of personal property listed here, they're going to say, okay, well, we raised the price of the purchase to include the value of all of that personal property. So your appraiser is going to start assigning a value to that personal property and reduce the sale price of the property. And that's not what we want to have happen at all. So the special verbiage there, and please don't go any further than washer, dryer, and refrigerator. There are things then also that are going to show up on the seller's disclosure that your buyer may not want, such as the refrigerator and washer and dryer. So the exclusions category is a little bit different. You can put anything in the exclusions category that is listed on page 7 of the seller's disclosure, or in that pre-printed list that's on page 6 of the seller's disclosure. Anything that the seller is saying is conveying with the property that the buyer wants removed. Paragraph 1B is for things that we want included. Paragraph 1C is for things that we want excluded, taken away. Paragraph 1D. Paragraph 1D is all about any additional terms and conditions. You're not attorneys, so be careful what you put in here. But there are a few things that you might want or need to include in here for on your buyers, from your buyer's perspective, to protect or make your buyer's offer as attractive as possible, or to protect your buyer. So be careful what you say. We need to be specific, but not too specific here. So such as I think the example that Kristen used to use on her when she was doing this for you all was the dead tree that's back in the back corner of the yard. Seller to remove the dead tree in the northeast corner of the backyard. So we want to know what's going to happen. The seller's going to remove it, and exactly what we're talking about, the one that's in the northeast corner of the backyard. Another thing, because there are a few things that are not addressed in our contract. That's the only thing that you're going to put in paragraph 1D, things that are not addressed anywhere else in the contract. If you know that your buyer's in competition with a lot of other offers and your buyer's in a position to do so, one other thing that you might think about doing that is not addressed anywhere else is for the buyer to offer to pay some of the seller's closing costs. We usually think of asking the seller to pay the buyer's closing costs, but if your buyer's in a position to do that, there's no other place in the contract to put that other than here in paragraph 1D. So buyer to pay $1,500 of seller's closing costs or whatever. So anything that's not addressed elsewhere. If you have any question about that, come talk to me about it, talk to one of the coaches about it. But that's what paragraph 1D is for. Paragraphs 1B and 1C are all about the personal property or things that systems in the property, things that are addressed in the seller's disclosure. Yes, ma'am.
So that's where that's where you can say the buyer's paying some of the seller.
Because that,
Not the other way.
because elsewhere in the contract, we have a place for asking the seller to pay the buyer's closing costs, but there's nowhere else in the contract that the buyer's going to pay $1,500 towards you. But yes, that's not addressed elsewhere, but the seller paying the buyer's closing costs is. All right, and we're still in paragraph 1, but the last two boxes in paragraph 1, something that you all have to address here on page 2. You either have to check at the box that's on line 83 or check the box that's on line 85. I'm going to guess if you all were at the breakfast last Tuesday, you had the opportunity to talk to, I know that Kent was here, Kent Lubinsky with Cinch, and I'm guessing that Janelle was here. I'm pretty sure I saw her here also with Old Republic. You have to have the conversation with your buyer about whether they want a home buyer's warranty or not. You have to have that conversation. It is addressed here in our contract. It is one of the things that has to be, we have to prove to put your errors and omissions insurance into effect for you, is that conversation was had with the buyer. So you are checking one of those two boxes. Either the buyer is waiving the opportunity to get a home warranty at this time, they can always get one later, or that they are going to want one in place at closing. And here we either indicate that they are purchasing it themselves or that the seller is going to purchase it for them, and the details about what company, what provider you're using, and what the per claim deductible is there. So you have to check one of those boxes. If you check the box on line 85, you also have to address the boxes on line 91 about who is going to be following up and ordering that. It's either going to be you, which it will, that's going to be the second box that's on that line, or you're going to ask the listing agent or the licensee assisting the seller to do that. I really prefer to see that you are the one that is going to be doing that. That way you know that it's been done. Line number 2 are all of the addenda paragraph number 2 are all of the addenda that we deal with in the contract. There's some pre-printed ones here that are the most common ones that we use, or there are then other ones that you can add to it. There are a lot that you would typically add. The seller's disclosure and condition of property addendum is listed there, so you would check that box if there's one provided. If there is not one provided, you do not check this box, and you have to address that up in paragraph 1D. That buyer and seller agree that they're acknowledged that there is not a seller's disclosure included in the contract. Lead-based paint disclosure, I'm going to ask my people that are here with me in person, What year is important for us when we're dealing with the lead-based paint disclosure? If the property was built before. Anybody in here know?
75. 78.
78, exactly. Property built before 1978. There has to be, has to be a lead-based paint disclosure addendum. This is a federal requirement. The seller's letting us know if they are aware of any lead-based paint on the property or if they have ever done any testing, and if so, they have to provide those reports. You may see various forms of that come through. There is one that KCRAR provides for us, but there are other versions of that. As long as it has all of the required disclosures and places for the buyer to acknowledge having received the information and having received the lead-based paint pamphlet from you. Again, when you are doing your buyer folders in dotloop, just go ahead and regardless of what the buyer tells you they're looking for, even if the buyer tells you they're looking for and will only buy new construction, please include that lead-based paint pamphlet. It should be in every buyer's folder. But and the contingency for sale and closing, if your buyer has to sell and or close on their current property, then that would be the contingency. There's another form for that, but you would check the box here. You will probably most of the time see the co-op agents franchise disclosure included here that they are asking your buyer to sign. So that would be something that you would add. As we're heading here into colder weather, you might run across the cold weather waiver for inspections with there's certain equipment in the property that we can't test as the temperature gets down below 70 degrees. There might be the as is and its present condition addendum that you might use. You might use the appraisal waiver. So there are all kinds of other addenda that you might include here. Things not to include are the buyer's pre-approval letter. That is not part of the contract. Our franchise and affiliated business disclosure, except it's not our franchise disclosure anymore, our affiliated business disclosure, we don't ask anybody other than our clients and customers to sign that. So that is also not part of the contract. So if you have any questions about that, anything that might be listed in MLS, talk to me or talk to your coaches about whether that's something to be included as contract addendum. So then everybody initials that. Paragraph number 3. I do need to keep my eye on the clock here. Because in this one, I know you don't always in all of your launch classes take a break, but in this one I do because that's the teacher in me, right? All right, paragraph number 3, descriptions and conditions. So there are lots of terms in here that you need to be familiar with, and you might want to make sure that your client or customer is familiar with them as well. The effective date. The effective date is important to us because all of our other timeframes throughout the contract refer back to the effective date. So the effective date in this particular version of our contract is established by the date of the last signature or initial to the contract. Effective date, very important to know. Seller's disclosure status, we're asking the seller to keep us updated on anything that might happen to the property of a major or minor concern. We've got a couple of those kind of floating around right now that I'm dealing with as the broker, but what's major, what's minor. But please, seller, let us know if if anything should happen. And we understand that that was the condition as of the date that the seller signed it, but please keep us updated on things. There are no other, paragraph 3C is all about that this is the complete document. If there are addenda to it, they are acknowledged and signed by all parties, and there are no other versions of this contract out there floating around. The parties here are established as the buyer and the seller. We use the term buyer and seller regardless of how many sellers there might be or how many buyers there might be. The brokers or the agents involved on either side of this, unless they are one of the buyers or sellers, but the brokers or agents are not party to the contract, unless that agent is a buyer or seller of the property. We are beneficiaries, possible beneficiaries of the contract as we get into paragraph 4, but we are not parties to the contract. Things about us, unless it's the required disclosures that we have to make, have nothing to do with the contract. And then talking about those required disclosures, we get down here to lines 136 through 143. If you are a party to the contract, if you are a named seller or a named buyer, you have to check the box on line 136 and then identify yourself as the seller or the buyer there, and let all parties know that you are licensed. Most of you, I think here, if this pertains, if you are the buyer or seller of the property, I think most of you are or will be licensed in both Kansas and Missouri. If you are licensed in any other state, we require that that disclosure be made also. So check any of those boxes that apply. Starting on line 140, you are disclosing to all parties if you are an immediate family member of either a buyer or seller. So immediate family member, basically by both states, defined as parent, child, sibling, spouse. And I would even say, because Missouri includes it, fiance. So, and the reason that we have to make this disclosure is not that people are concerned that you're treating them better than you would treat any other client. The reason we have to make this disclosure here is because of a possible future interest you could have in the property. If you are selling to an immediate family member, by the laws of descent in Kansas and Missouri, you could be inheriting that property at some point. So that's why we have to make that disclosure. Our notices here tell us that all of our communication can be either in person or electronic. That includes phone, email, text. All of that, the courts have determined that all of that is applicable. Time is of the essence is the phrase that tells us that everyone is working as hard as they can to fulfill the requirements and obligations within the contract. And a couple of the definitions here of banking days or business days. If banking days or business days are not being used, then a day is a 24-hour calendar day. Our days per the contract start at midnight. So end at 11:59 and begin again at midnight. Talk about that a little later too. Cyber awareness, please make sure that you're telling all of your customers and clients that there is a high risk of emails being hacked. Real estate agents, title companies, and lenders are at very high risk of that. So if your client or customer receives anything requesting personal information or requesting financial information, make sure that whoever's received that email has verified that that email is legitimate. Don't have them tell them not to call the phone number that's on the email, that they're calling a phone number that they've gotten somewhere else, either from you. Have them call you and you can help them verify, because that happens more than you might like to think. Paragraph number 4, we're finally here in our purchase price, financial terms, closing, and possession. So we'll get into the details of this on Wednesday, but this is all of the financial information about your buyer. The purchase price, the earnest deposit that they are putting down, if they are putting down any additional earnest money at a future date, we address that here. We also are identifying where the earnest deposit goes. We'll talk about that on Wednesday as we pull up an actual MLS property. We'll probably use the property that we use for the contract challenge here, but that the MLS tells you where that earnest money is going to be held. So then a little bit of calculation going on here, the amount of the buyer's loan, and then the amount of that they're going to have to bring to the closing table. Yes, ma'am.
Where?
On MLS, and we'll talk about that in Wednesday's class. That's one of the fields down close to the bottom, kind of as you're looking at the MLS sheet down on the bottom right-hand corner. It says earnest deposit or deposit to, I think is what it says. So, and that tell you, and it's always going to be where the seller has chosen. Or the listing broker has chosen for the seller, but in our world, it's the seller, but it's always up to them. All right, so then to paragraph 2F is where we deal with, then we've got our purchase price and loan amount established up in the top part of this page. Starting on paragraph 4F, we're talking about then on line 206, if the buyer is asking the seller to pay your compensation, that's what we put on line 207 there. Additional seller paid costs, this is where it's right in here in the contract, if we are asking the seller to pay some of the buyer's closing costs, goes on in here. And then you really are not going to probably deal with line 216 too much, unless your buyer is working with a lender, like a lender down payment assistance program. That might not allow the buyer to pay for certain things associated with that loan. Most of the FHA, VA, and USDA allow anyone to pay the buyer's closing costs. So rarely would you use anything on 216, but it's still there because some of those really specialty loan products might have that in there. And so then on line 218, we total everything that we're asking the seller to pay, in addition to the things they've already agreed to pay elsewhere in the contract. Everybody initials that page. Some terms, and then in paragraph, we're still in the finance here, some financing terms, what loan costs are, the difference between PMI and MIP. I hope you all know that. VA funding fee, USDA funding fee, and then we deal with the flood insurance possibility. You have looked at the flood maps as you have been showing the property, but and you see whether you think it's impacted by whether the property is impacted by any of the marked flood zones on the flood maps, but it is not your interpretation that anybody cares about. It is all about the lender and FEMA, whether they determine if flood insurance is required, but it's a conversation for you to have with your buyer. If it appears to be either close to or directly impacted by a flood zone, have that conversation with your buyer. You really should have a conversation with the lender before you write the contract also. Paragraph 5, we're dealing with our closing and possession dates. Please make sure that you are choosing an appropriate date here. Again, we'll get into the details of that on Wednesday's class. I do like to make this point specifically though, down here when we're talking about possession date. No, actually, before I do that, since we're talking about the specifics of the contract here today, starting on line 243. On or before the closing date, buyer will execute and deliver into escrow with the title company or other closing agents all documents, including notes, mortgages, deeds of trust, or any other documents required by buyer's lender if buyer's obtaining financing and funds, including loan proceeds if buyer's obtaining financing necessary to satisfy buyer's obligations under this contract. The buyer's closing happens when the buyer has signed all of their documents. Seller and buyer acknowledge all funds required for closing must be in the form of cashier's check, wire transfer, or other certified funds. Please don't let your buyer think that they can bring a personal check to closing for all of that. And then on line 251, because there's so many experienced agents out there in the world that don't understand and know what this is. So really important paragraph in our contract. When all documents and funds have been executed and delivered into escrow with the title company or other closing agents, the closing will be completed. When all documents and funds, buyer side and seller side. Just because your buyer signed their paperwork doesn't mean that closing has happened. Seller has to have signed all of their paperwork also, and both parties have to have brought all of their funds necessary, if any, to the closing table. Seller will deliver possession of the property to buyer on, and on line 253, we have a date. Please put a date in here. Don't put, and this is coming from your broker here, folks, do not put at closing or at funding. Put a date. If it's going to happen at closing, that's already covered for you. That's what our default is in here. If you are going to put a date in, then make sure that you put a time in as well. We cannot enforce at funding. There's nothing there to enforce. At closing is already covered in the contract because that's what our default here as we get on line 253 already says. So don't put at funding or at closing. If it's going to be other than at closing, then put in a specific date and a specific time. And in our world here in Kansas City, it's not unusual for us to allow the seller another day or two after closing to occupy the property. If they are still living there, as you're showing the property and you know they're not moving out, that's something, again, a kind of a negotiating tool that you have. If your buyer can do that, is to allow the seller to stay for another day or two. Don't let it go past another day or two without making other arrangements as far as rent and that kind of thing. But it's not unusual. We're kind of nice here in the Midwest, right? Sometimes the seller has to have those funds before they can move on and do what they're going to do. If it's a vacant property, just leave line 253 blank. And and then possession happens at closing. Closing being defined as the time after which all funds and documents have been delivered to the closing agent. And then our default here, if left blank, and I'm looking at line 253, possession will be 5 p.m. on the closing date. So it's already covered. Don't put closing, and do not put at funding. Then it also tells us here in the same paragraph that the buyer should not occupy the property or place any personal property in the garage or anywhere else on the property until, and then the whole paragraph there, completion of the closing and disbursement or availability of seller's proceeds, if any, unless otherwise agreed upon in writing by the buyer and seller. We do have an occupancy prior to closing form. We don't like to use it, but it is there. Everybody has to have insurance in place, and so all kinds of special things there that have to go on. Okay, it's 9:53. It's time for our break. So I'm going to stop share here. No one else has joined us. Jody and Amber, I'm guessing, are still hanging in there with me. There's a
Yep.
chat here.
Still here.
Okay,
still
Amber got her
here.
scenario for the
Yes.
contract challenge. Anna, I think you asked me for one too, didn't you? Yeah, okay. Daniel, I'm not sure I've heard from you if you're going to participate in that
Hey,
or not.
we say that again, what is
The
it?
contract challenge that we do with Wednesday Night Warriors.
Okay, I'm not familiar, so
Okay.
I work until like 7 o'clock.
Well, you don't have to participate in Wednesday Night Warriors to participate in the contract challenge. And we do actually require everybody at some point in their time and launch to do a contract challenge.
Okay.
So, so what the whole thing about it. So we're taking breaks. So I'll see you all in 10 minutes.
Hey, Tarun. Can you hear me? I'm good. How are you? Yeah. Uh-huh. Yeah. It's not even so much of the background issues. Like, so for example, uh, I was trying to pull up this guy on here. And when I go in, can you see what I'm doing? I'm like typing up their name and then I'm clicking on this. I'm clicking on this, but it's not popping up anything for me. Right. Right. Correct. It was not opening up at all. Like this, like all today, it wasn't opening up at all. Like even this right now is the older one. Like, okay, so when this guy called, it popped up as a unknown only with a phone number. But when I found out his name, I saw that there was a there was like a lead in here or whatever. So when I was like trying to click on it, it just wouldn't pop up. And even right now, I think that there is a lead with his information on there because this is the lead I added his name and the address to, but then there is a lead with his address. So when I go to click on anything from here, this section, it doesn't automatically populate. Like it just takes forever. See how here's like two, right? So when I was trying to pull up this one, it just was not pulling up just under his name. Mhm. Yes, correct. What do you mean next one? Yeah. Yeah, exactly. So he called me from this number, which was his cell phone number. Right, right, which is fine. What I'm saying is while I was talking to him, he got a letter from us, so I knew he has an account with us, right? So the whole time I am talking to him, I'm searching for his name and I found it, but when I was clicking on it, it does not pull it up. It just goes absolutely blank. Like the entire screen just goes white, absolutely blank while I'm on the phone with him. And I tried it I think we talked for like 20 some minutes, and the whole 20 some minutes, the screen just would not come up for me. And I closed it, I refreshed it, and like opened it again, nothing. Okay.
Okay, we're back. I'm sure Daniel will be back. So share screen again. Move everybody to. Okay, so I finished up then with the closing and possession paragraph there. Paragraph number 6 is about the appraised value contingency. So this is, as you again all remember from your pre-license class, I'm sure, that the lender will only lend based on the loan that the buyer is applying for on the lower of the sale price or the appraised value. So that's why we deal with that here in the appraised value contingency. If there is a discrepancy, if the appraisal comes in lower than the sale price of the property, then we have the ability to, number one, either party can cancel the contract and or renegotiate in there. So if that should happen, the buyer has to send the appraisal to the seller, regardless of what the buyer's wanting to do. We have 5 days to, and again, that the default in here is blank calendar days after the effective date of the contract within the inspection period. So as far as getting the appraisal done, we do have a lot of lenders that will wait until after the inspections to get the appraisal done. And that's on a cash sale. I'm sorry. I'm getting confused here this morning. So if it's a cash sale, the buyer has within the inspection period to get the appraisal done. We have a lot of lenders that will allow for it, if time allowing, unless you've asked for a short closing, we have a lot of lenders that will allow the buyer to get through the inspection process and get everything renegotiated there before they'll order the appraisal. So once the appraisal is ordered, and then down here in the second part of that paragraph on line 268, is when if the final appraised value of the property is determined by the buyer's lender's appraiser, it's always the buyer's appraisal, but the lender orders it. Or if it's a cash sale, buyer's appraiser is not equal to or greater than the purchase price. So if it comes in less than our purchase price, the buyer will notify seller in writing within blank calendar days, and we have our default of 5 days there. All of our blanks have defaults to them, and this is, you can change those, but there's not, we'll talk about some of the times when maybe you want to change them on Wednesday when we're going into the negotiation, but just make sure that you are aware of what all of the default days are throughout the calendar. If you are dealing, if you're not going to change it, leave it blank, please. It gets confusing, I think, when some agents, when they're filling in the contract, the blanks in the contract, will retype in the blank what the default is, what that's already printed in the contract on some items, but not on all items. So if you're going to type the same number in there, make sure you address every single blank, because otherwise I think, oh, well, you meant to change it and you just, kind of had a mind blank and put the same thing in there. So please just leave it if you're going to leave it the same. Buyer and seller have blank calendar days. And again, it's 5. We have the period of time that the buyer has to get the appraisal to the seller. And then once the seller has it and sees it, we now have our appraisal negotiation period of 5 days to reach an agreement resolving the appraised value. Difference between the two figures. During this period, seller or buyer may seek a reconsideration of value by the appraiser if such reconsideration finds a value equal to or greater than the purchase price, or if buyer and seller sign an amendment resolving the difference between the appraised value and the purchase price, the transaction will move forward to closing. You can always ask the same appraiser, mind you, to reconsider that appraisal. I would only do that if you have evidence of comps that you have that they didn't use on their appraisal. And also bear in mind, you're asking the same appraiser to reconsider what they've done. You're basically saying to them, well, I don't think you did a very good job. So make sure that number one, you're handling it properly, and number two, that you can justify your request for reconsideration. Don't just say, "Oh, I don't think this is right, just do it again." Right, it's going to cost, number one. And then must be important because it's in bold on line 281. If no resolution is reached prior to the expiration of the appraisal negotiation period, then after the expiration of that 5-day period, either party may cancel this contract by written notice to the other, and buyer's earnest money will be subject to the provisions of the earnest money and additional deposits paragraph of the contract. Two things there. So you have to wait until after the 5 days is expired unless the two parties agree to do it beforehand, before either party can unilaterally cancel the contract. The buyer's earnest money, and I hear agents say say wrong things all the time, and this is one of them. Please, 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 if you're in this situation, don't say to the buyer, "Well, you can cancel the contract and get your earnest deposit back." Because those last two sentences there, that the earnest money will be subject to the provisions of the earnest money and additional deposits paragraph, means that state license law in both states, state escrow laws in both states, tell us that both parties have to sign off on any disbursement of those funds other than at closing. So the seller has to agree to release that money. So don't ever just guarantee the buyer that will get their money back. You can say, well, it is subject to, we can reasonably expect for you to get it back, but the seller has to sign off on it. Either party can cancel if we haven't come to a conclusion after the expiration of that negotiation period. Paragraph number 7 is all about if the buyer does have to sell and or close on their current property before they can purchase this one, contingency or sale contingency, we would check the appropriate box here, which would be line 290. Once again, you have to address one of these two boxes, making it perfectly clear whether this is subject to a contingency or not subject to that contingency. Paragraph number 8, we're getting into all of the financial terms. If the buyer is getting a loan, on line 296, if it's a cash transaction, the buyer is not making it contingent upon financing, then you would check the box on line 296 and ignore the rest of this paragraph. If the buyer is getting a loan, you check line 299. You have to check one of those two boxes as well. Again, making it perfectly clear. If it's a cash transaction up on line 296, we are giving the buyer 5 days in the contract to get their proof of funds to the seller. Proof of funds can be either bank statements or a letter from the lender or the financial manager. And we also need to make sure that those funds are readily available and can be accessed before closing. I've had so many times when we've had a closing scheduled and the buyer didn't know it was going to take them 60 days to get money out of their account, and that causes a huge problem. So we need to make sure that those funds are available when we need them for closing. We are told in the next paragraph, starting on line 302, that we are telling the seller here, our lender, what kind of loan we're getting, some of the terms of the note that's going to be on the note. The buyer can change the lender they're going to and the type of loan they're getting, as long as it doesn't affect the seller. If it's not going to extend the closing or that the seller has to pay additional money other than what they've agreed to. It's always required that if you are going to change, if the buyer is going to change their lender, that you have to notify the seller. If it's going to change anything about the seller and the closing date or additional money, the seller has to agree to that. So the buyer can change some of those things. It's just that we have to have paperwork backing all of that up. On line 311, once again, you have to check one of those two boxes because we're letting the seller know, is this going to be owner-occupied loan or investment loan? There are different requirements for those two kinds of loans. That's why we're letting the seller know that. Then in paragraph 8B, we're then letting the seller know the terms of the loan that the buyer is applying for. All of our options there as far as the category of loan, the type of interest and the interest repayment plan that the buyer has is going to be applying for the amortization period. That's going to be the length of the loan. Is it a 15-year, 20-year, 30-year? You know, we've heard rumors of other timeframes coming into play. I hope nobody takes advantage of that. Seems like a really bad idea to me, but you know, whatever. Alana, on line 330, principal amount or loan to value. So you can put either one in there. Loan to value is that ratio. If they're putting a 20% down payment on the loan, then our loan to value is expressed as 80/20. If it's an FHA, then it's 96.5/3.5. You can put the principal amount in there, but if you do, and there's a renegotiation and the price changes, then we have to remember to come back and change that principal amount on this form as well. Loan to value probably is not going to change, even if there is some negotiation on the price. So I think it's always better. There is a second column there for a secondary loan. We're not seeing many of those there, but sometimes in that lender down payment assistant type programs, there is a secondary loan. So you'd have to fill out the information on both. Most times that's not going to be part of your writing of the offer. Yes, ma'am. Sometimes when the borrower is getting a down payment assistance program loan from the lender, that actually is a loan for the down payment and then a loan for the loan. And so then we are actually in a two loan situation there. Okay, and the terms would be different on them. We are in subparagraph C, we're identifying whether the buyer can float the interest rate or whether they're capped at a certain interest rate. We'll talk about that on Wednesday. In paragraph 1D, we're identifying the loan application, where the loan application is being made, the institution. You can always put the loan officer's name in there. That's great. And the loan officer's phone number in there. That's great too. But what has to be in there is the lending institution. I hope, and you'll always be checking line 253. Please don't ever be in the position to be checking line 361 because you shouldn't be out showing properties to buyers without having that pre-approval in hand. So please don't ever have to say that the buyer's not yet pre-approved. You're not putting yourself or your buyer into that position. Then we're getting to the loan approval process down here. So again, rights and responsibilities within the contract. The buyer agrees to make a good faith effort to obtain a commitment for the loan within blank number of days. 45 days is our default. You don't want to shorten this because it's 45 days or 5 days prior to the closing, whichever one comes sooner. You don't want to shorten that because you are now making a promise that the lender has to fulfill. So don't shorten that. However, we are saying here that the buyer is actually making loan application in a certain period of time. We said that a little up there, but this is getting the loan commitment. This is one of those things that I think a lot of agents overlook. We are getting a commitment from the lender saying that the buyer's been qualified and the house has been qualified through the appraisal. And yes, we as the lender are agreeing to make these funds available to the buyer. That's what that little paragraph is all about. It's very important. That is the one and only way that we have to prove that we provided a ready, willing, and able buyer. A lot of times it gets down to the wire and it's, you know, at the last minute before all of the disclosures have to be made 3 days before closing. Sometimes it's within that 3-day period. But the clear to close is the verbal commitment. We really, really, really like to have a written commitment from that lender. And you can look like a smart agent asking for that. So talk to the lender about that. Hey, can we have the commitment letter? Can you send that over so I can put that in my file? If they can't get that commitment, then, you know, things change in here. Line 372, if the buyer is unable to obtain a written commitment from the loan with the loan approval period, seller may cancel this contract by written notice. That's why it's really important for us to have the evidence that we have that commitment. The seller can unilaterally cancel the contract if the buyer can't prove that they can get the loan. The second part of that paragraph, or the next part of that paragraph on line 375. Upon written evidence of rejection provided by buyer's lender, buyer or seller, either one may cancel the contract by written notice. If your buyer cannot get the loan, if something should happen, something comes up in the loan application process that prevents them from getting the loan. Again, in writing, we have to have that from the lender. Send that to the seller. You are under legal obligation to send that to the seller as soon as you know that. So you have to have that in writing as well. Yes, Anna.
Where,
In the buyer docs. And then that can be provided to the seller upon request. And in fact, it's probably not a bad idea just to go ahead and send it. But in your loop, so I think that's what Anna was asking. When you get that commitment letter, put it in your buyer docs. It's really not a contract document because it's not something that both parties agree to, but it is fulfilling an obligation that the buyer had within the contract. So good question. All right. Yes, and as I said, make you look like a really smart, on top of things agent. And that's what we want because you are. That's right. All right, so paragraph F, lender appraisal requirements. Again, I think this is one of those things that is overlooked by most agents in the contract. Sometimes I talk to agents about this and they're surprised that this is even dealt with in our contract, but on every loan, regardless of whether it's conventional, FHAV or USDA, one of the federally related loans, there may come back with the appraisal some requirements that the appraiser has put on, that the lender will then require to be fulfilled before they will approve the loan. It's more common in the federally related loans. And so you, with your realtor eyes, as you are looking at the property, walking through the property with the buyer, you're seeing if there are handrails missing, if there are downspouts missing, if there are gutters missing, that's another one. If the property was built before 1978, if there's cracked or peeling paint, those are things that just about every appraiser on a federally related loan is going to see and point out. There are other things that the appraisers have a big thick book of things that they're supposed to be checking. A lot of appraisers don't go through that book. A lot of them have their own hot buttons. So sometimes you're going to be surprised by what a lender's or what an appraiser is going to tell the lender. But if you see those things prior to putting in the offer, that this is your opportunity on line 382 to put a dollar amount in here that will obligate the seller to pay, if the seller agrees, to pay a certain amount of money to make those repairs. $1,500, whatever, $500, whatever you think might cover it, or at least make a dent in it. Because the thing about it, those requirements, those repairs, they have to be done before closing. We really then expect the seller to do them. A buyer can't make repairs to a property that they don't own. I'm just going to put that out there. So, all right. So again, with your realtor eyes, if you're seeing those things, address it up front. Condition maintenance and inspections of the property. Paragraph number 9 is all about the seller agreeing to leave all their utilities on throughout the executory period of our contract. We of course want them on for inspections. We need them on for inspections, and it is best for everyone to keep them on throughout the transaction. As we're heading into cold weather, as we're coming out of hot weather, doesn't matter. The damage can be done to the property in extreme cold weather or extreme hot weather if we're not keeping the inside temperature at a reasonable temperature. Doesn't have to be super cool in the summer. It doesn't have to be super warm in the winter. We're really taking care of the property there. Maintenance of the property, paragraph number 10, seller agrees to maintain the property in its present condition. I've had several broker questions come up just recently about this. Well, but this happened. Does the seller have to take care of that? Well, the buyer has the right to expect the property to be in the same condition as it was when they saw the property. Even if it happens overnight after the seller's final walkthrough. Yes, the seller agrees that they're going to maintain the property. If anything should happen, then it is their obligation to let us know as soon as possible. Insurance and casualty loss, paragraph number 11. This is another one of those really interesting ones. If something should happen to the property that might require or should require or does require, or I shouldn't say require, might or should or does indicate that an insurance claim be made on the property, and again, seller owns the property still up until closing. This paragraph deals with that. Lots of options that the two parties have. And yes, we do have these things come up. I've actually, it was a couple of years ago, but actually had the house catch on fire and, you know, pretty much was destroyed in the executory period of our contract. So yes, it does happen. Water leaks happen. The pipes burst. During a storm, a tree will fall on a property. So yes, this stuff does happen. That's why we have a whole paragraph. We have a 16-page document here. Most lines have been added. When I first started selling real estate, it was a one-page document. That's how, you know, back in dinosaur days. But there's the reason all these things have been added is because something's happened. We had a disagreement between the parties or life happens. So insurance casualty loss. Again, I'm not going to get into a lot of detail with this. We hope it doesn't happen to you, but it will. Just remember that there are lots of options in here. Buyer and seller agree to consult with their respective insurance companies to ensure appropriate coverage during the time between completion of closing and possession. The reason that sentence is in there is because we do have that occasional time when we're allowing the seller to remain in the property for a couple of days, or that occasional time when we allow the buyer to take early possession. When the buyer doesn't yet own the property, but is living there or has some of their property, their personal property there, they have to have insurance coverage. If we're allowing the seller to stay, whether it's just for a day or two, or we have an extended agreement for an occupancy after closing, the seller has to have insurance in place also. They no longer own the property. So there's a balance there. That's really why we don't like to see that, again, the day or two, and it does get tricky if we're just allowing the seller to stay there for a day or two without rent, because whose insurance covers if something does happen? So personal property stuff versus real property stuff. All right, if before delivery of the deed to the buyer, the property is damaged or destroyed by fire or other causes, including those that could be covered by what is known as fire and extended coverage insurance, then the seller must notify the buyer in writing within 1 calendar day of discovery of self-damage. There's really no downtime there. We have to let them know immediately. We have to be, we have to be notified immediately, coming from the buyer's standpoint. The parties agree that the risk of that damage or destruction will be borne as follows. Number one, if the damage is minor, and that's such an important clause there. Who determines whether the damage is minor? We've got one of those situations ongoing right now. Buyer didn't think it was minor. Buyer thought it was pretty major. Seller says, oh no, that's no problem. I'll take care of that. Well, but it could take weeks and months to do that. So if the damage is minor, seller may repair or replace the damage done to the property if the work can be completed before the closing date. That's the catch there. Right? That might determine whether it's major or minor. If the seller elects to repair or replace the damage on the property, but repair replacement cannot be completed prior to the closing, with written agreement between the parties, one of the following options will be chosen. So again, we're talking about rights and responsibilities of the party. That's what we're dealing with here, parties. That's what we're dealing with here today. Seller will pay for a repair replacement after closing, or the parties will extend the closing date to such time as repairs replacement can be completed, or with consent of the buyer's lender, and because we have lenders get involved in these things too, 1.5 times the estimated cost of repair replacement will be escrowed until repair replacement is complete, with any funds remaining after payment for repair replacement being remitted to the party that funded the escrow. So if we're asking, if the seller agrees to make repairs, but the repairs can't be done prior to closing, the lender may require that 1.5 times the amount of the estimate for that repair be held with the title company. And then when those repairs are completed, the contractor will then let the title company know, who will then disperse the money. You know, we don't trust anybody here. Seller says, yeah, I'll pay for it afterwards. And then, you know, they leave town and we never hear from them again. So that, and the 1.5 times is because even though we've got an estimate for repair or replacement, things come up. You know, either costs go up, materials, or something shows up that was unseen at the time the estimate. So 1.5 times the repair or replacement cost is put into escrow. B, if seller elects not to repair or replace the damage done to the property, or if the damage is not minor, the buyer may enforce or cancel this contract by written notice to seller within 10 calendar days after receiving such notice of such damage to the property. If the buyer elects to enforce the contract, the purchase price will not be reduced and the property will be conveyed in its existing condition at the time, provided the seller must furnish buyer with a copy of the insurance damage assessment and be responsible for paying the insurance deductible and assign seller's fire and extended coverage proceeds to the buyer at closing. Really long sentence there saying that if the buyer says, no, I will go ahead, I want to go ahead and buy the property, we're making an insurance claim on it, the seller still has to pay the deductible, and then any monies then that would be coming to the seller have to be assigned to the buyer. That's one option. Option number 2, if buyer and seller mutually agree upon the cost of repairs, then seller may pay the cost of those repairs if it's not being an insurance claim. So it gets kind of complicated in there. If this situation does happen to you, and you know, chances are it will at some point in your career, please go talk to your broker about what the options are, clarify the options, and make sure that you are doing what your client wants to do, but you're giving them good information upon which they can base their decision. Paragraph number 12, the survey, our paragraph about surveys here starts out saying that the buyer, at the buyer's expense, may obtain a stake survey of the property no later than, and we have 10 calendar days as the default here, prior to the closing to ensure there are no defects, encroachments, overlaps, boundary line, or acreage disputes, or other such matters that would be disclosed by a survey. Why might your buyer want to get a stake survey done? If they're buying a property, they know they're going to be putting a fence up. And number one, if there never has been a fence there, it's a really good idea to make sure that the fence is put on exactly on the boundary line or just inside it. You don't want to put a fence up on someone else's property because they have the right to tear that down. Even if there is a fence there and it's questionable as to where the property line might be, stake survey is our only way of determining where the exact property lines are. If we think that this property has encroached upon maybe a setback by the city, maybe if there's something about the property that is maybe in an easement or gotten too close to the property line, because all of our cities have property line setbacks and we can't put any improvement within blank number of feet from the adjoining property. If we think there's any question about that, survey should be done. That is our only way of providing evidence for. And we want that done if the buyer is going to do that. If there's a question, this could become a material fact for the buyer. It could be something that would change their mind about closing on the property, but don't want to pay for a survey and until and unless we're under contract on it. But if they're going to make their decision on whether to close, then that's why it has to be done no later than 10 days prior to closing, so that there's negotiation time or then enough notice for cancellation of the contract there. Paragraph number 13, we spend a lot of time and, after our initial negotiations, the inspections probably are the second most common thing for us to spend the most time negotiating here. Paragraph number 13, and it's a really long paragraph, but dealing with the inspections and the inspection period. We establish our inspection period on line 462. Buyer may within blank calendar days, and our default here is 10. On Wednesday, we'll talk about some of the negotiating tactics, why you might want to change that. But 10 is a reasonable amount of time. And whatever time is agreed to by the two parties is now known as the inspection period. The inspection period starts at midnight. Okay. we sign our, let's say we sign our, both parties sign the contract today on 11/17 at some point today. Our inspection period starts at midnight tonight. So we always start with one full day, the day after the last signature on the contract. That tends to confuse agents sometimes, and how do we count the days? But it always starts at midnight the day after. We always start with the full day. Our list there of things that can be inspected, it is certainly not an exhaustive list there. And our inspections have to be done per line 463 and 464, an independent qualified inspector. The obligation of your buyer is to find that independent qualified inspector. Neither Kansas nor Missouri require the inspectors to be licensed. However, they really should be a member of one of the inspection company associations. ASHI, NACI, NACHI, I don't even pretend to remember what all of those stand for, but ASHI, ASHI. So these are professional associations, and we really do want our inspectors to be a member of at least one of those to be called an independent qualified inspector. We can't go by the buyer's Uncle Joe that came in with his flashlight and screwdriver to check things out. That does not count. All right, but then our list there, but once again, not an exhaustive list by any stretch of the imagination, but it does cover most of the things that most buyers would want covered there. It's buyer's on line 472. It is buyer's responsibility to perform due diligence and verify any information that buyer considers to be material to the purchase of the property. That right there is what, again, one of the things that causes a lot of problems for agents on both sides of a transaction there. Buyer's responsibility to perform due diligence and verify any information that buyer considers to be material to the purchase of the property. This becomes, by that sentence, our due diligence paragraph. Due diligence meaning that we are checking out anything that might affect the buyer's decision to buy that property. We are checking out the HOA restrictions. We're checking out the zoning of the property. And again, when I say we, you're helping the buyer do this, but it's the buyer's, it's really the buyer's responsibility, but I think it's your responsibility to help them with that. Not, and it's dealt with specifically down here on line 479, because not the least of which we are checking out is the insurability for the buyer of that property. They need to, as soon as they are under contract, contact, and this is you telling them, they need to contact their insurance agent with the property address. The insurance agent will then go out onto their database called and get what they call a clue report, which will then let that agent know, that insurance agent know, any and all claims that have ever been made on that property. If there has been a water claim on that property, our buyer's agent may not cover that property because of the possibility of mold. There are all kinds of reasons why, and again, the agent checking it out to check for flood insurance requirements and that kind of thing. So due diligence is you and the buyer checking out everything that could possibly affect the buyer's willingness to buy the property. During the inspection period, this happened a while back, and it was our buyer on our side. We were representing the buyer. During the inspection period, because also remember this too, everyone. The buyers are making their decision to purchase a property after spending maybe 20 minutes in the property, maybe 30 minutes in the property, and then, hey, let's go write an offer, which is fine in and of itself, because I tell buyers all the time, you're going to know within 30 seconds of walking into the property, whether it's your house or not, but they haven't spent a whole lot of time there. So getting back to my story, we had buyers that at the inspection time spent time in the backyard and determined that the traffic noise they could hear in the backyard was too noisy for their autistic child, which I think is a valid reason. One of the things that I believe is covered by our line 472. Okay. any information. So we're not just limiting it to the physical things that are, I don't think, but of course, it's not our interpretation, but that's
Yes,
certainly
that
what I
would
would
be
tell buyer.
environmental, like,
Absolutely.
environmental realities of the property.
Absolutely.
Yeah.
Right. Okay, then we get down into some of the things that a property insurability within that we cover within our due diligence, our inspection period here. Factors affecting the inspections. By acknowledging such inspections may not identify deficiencies in inaccessible areas of the property and may be limited by weather conditions. We can't test the air conditioner. As we're getting into weather now that doesn't get above 70 degrees, like we say goodbye to your 70-degree weather. I apparently, for a while anyway. Then we can't check the air conditioner. It would hurt the compressor to run it. Obviously can't check any swimming pool equipment if the pool is closed. So those kinds of things, the property might be already winterized, and that's a whole different thing. Okay, so weather conditions, access to property and re-inspections. This is also something that tends to take some sellers by surprise, I think. Seller must provide buyer reasonable access to the property to conduct their inspections, re-inspections, inspection of any corrective measures completed by the seller, and or a final walkthrough. So we don't want, but here's the other thing on this too. If your buyer calls you and says, hey, can we, after inspections, hey, can we go back into the property and measure for carpet? Well, if it's a vacant property, you still have to make the appointment and make sure that that's okay. If it's an occupied property, you might say to your buyer, that's not one of the things that they have to allow us in for. You can ask, but don't necessarily expect, because now you are, when you're in that period of the contract, now the seller's probably packing stuff, and the house doesn't look, and you might not even have access to measure certain rooms and that kind of thing. It might not even be possible to. So let's be reasonable. That's what inspection period's for. That's a 2-hour period at the minimum on any size property for the buyer to be measuring for carpet, measuring for drapes, that kind of thing. And yes, I understand that you can't always get the carpet guy out there to measure during that period of time, but do what you can. All right. So damages and repairs, buyer will be responsible and pay for any damage to the property resulting from the inspections. If the inspector breaks something, seller's responsible for paying. If something breaks during the inspection, that's a whole different thing. So, all right, and again, talk to your broker, because you'll probably have something like that happen to you too. Quality of repair. Seller agrees any corrective measures which seller performs pursuant to the following provisions will be completed in a workmanlike manner with good quality materials. So once again, can they do some of the repairs themselves? Well, if they do a good job, yes. And that's why we have the ability to go back and check on those repairs that have been made. Wood destroying insects. This is huge, right? Okay, so another rights and responsibilities that we're talking about here. Seller agrees to pay to have the property treated for control of infestation by wood destroying insects if a written inspection report of a certified pest inspector reveals evidence of active infestation or evidence of past untreated infestation, or otherwise recommends treatment in the main dwelling unit or any included additional structures identified below or on the property within 30 feet of such unit or structure, or is otherwise required by government regulations if buyer's obtaining a federal related loan. Buyer will pay for any inspection requested by buyer and or required by buyer's lender. So that's a whole long paragraph, 2 sentences, but that first sentence is long but important. If a qualified pest inspector, and they are licensed in Kansas and Missouri, a qualified pest inspector finds evidence of current activity or evidence of past activity and can't determine that there's been treatment, and they have ways of determining that, or if for whatever other reason they say this property should be treated, our contract says that the seller is going to pay for that treatment. Our contracts, I'm going to repeat that. Our contract says that the seller is going to pay for that treatment. It says nothing at all about the seller making repairs caused by the damage. That's a negotiable item in our repairs, that the seller agrees to pay to have the property treated. bear in mind when on any of these things, at any point in our contract, when it says buyer does this or seller does this, everything's negotiable. Everything can be changed by agreement of the two parties. One of our in its present condition form, or as people like to call it, the as is form, which is really called the in its present condition form, that takes that obligation away from the seller. So everything's negotiable, but writing a good, clean contract without that addendum on it or with it, seller agrees to pay. The inspection report, and here on paragraph F, we are dealing only with the wood destroying inspection report. So inspection report must be delivered within the inspection period if any treatment will be at the buyer's expense. So has to be within whatever we've agreed on, 10 days default, but whatever that we've agreed on. You'll notice back up here, again, online, find the actual line here, 496 and 498 and 499. Anything within 30 feet of the property is included in the inspection report. So a shed, a deck, even if it's a freestanding deck, but if it's within 30 feet from the main structure of the property. If there are things in the yard that you want inspected that are more than 30 feet away from the property, that's where you would add things into 511. I have agents that try to add other things in here that they're going to, like the sewer line inspection. Well, number one, you don't have to write that in special because it's included in our previous list, and it has nothing to do with wood destroying insects. All of this is for that wood destroying insect report. And there's more than termites. Excuse me. Agents call it, and I do it too. We just kind of get lazy sometimes, the termite report. But they're checking for, there are several different kinds of wood destroying insects that they're looking for. Termites, carpenter ants, wood boring bees, and there's one other one that I can never remember, but they're checking for all kinds of things that could destroy wood, not just termites. What if the buyer does, and now we're talking in general now about the inspections. What if buyer doesn't conduct inspections and they have waived their right to make any renegotiations? What's an unacceptable condition? Anything that the buyer determines is unacceptable to them based upon that qualified independent inspection report. What if the buyer does not give timely notice of unacceptable conditions? Again, make sure you are paying attention to your time frame. So many times an agent has gotten the repair request too late back to the seller, and the seller's not obligated to do anything. And that's your job, is to make sure that everyone's time frame is being met. And so buyer waives their opportunity to renegotiate. What's not an unacceptable condition? There is no such thing as an unacceptable condition. What we are doing, or something that's not an unacceptable condition, what we are doing here is naming something that both parties agree the buyer cannot ask to be repaired or cannot take their right to cancel the contract because it's not working. Rarely would you put anything in here when you are writing a contract. You only would if you know that by the seller's disclosure that it's a 25-year-old furnace HVAC system, and your buyer maybe owns an HVAC company or knows is related to, and to make the offer attractive to the seller, you're going to say, oh, we will exclude the HVAC system from this. We won't use that as an unacceptable condition. So that's the only time that you would write something in here. Otherwise, we can address it later in a counteroffer. When the seller maybe agrees to take a lower offer than they were originally intending, and they say, okay, we'll take this number. However, you have to exclude the HVAC system from any repairs. So it's something that can be negotiated later. You may put something in there writing the offer, but probably not. What if the buyer's inspections reveal unacceptable conditions? Again, rights and responsibilities of both parties here. There are three options. When the buyer has their inspections done and there are things that come up, because things always come up on inspections, they can accept the property as is. They can cancel the contract unilaterally by notifying the seller, and their earnest money becomes subject to the terms and conditions that we'll talk about here in just a minute, or they can offer to renegotiate. this decision has to be made within the inspection period. What is the buyer going to do? So up until 11:59 of that 10th day, or whatever the two parties have agreed to, the buyer can make their decision to do any one of these three things. If they agree to accept the property in its present condition, then we just do the inspection notice, put that, check that box, and things are done. If they want to cancel the contract, and then that's when we get down to subparagraph I here. Buyer's notice of cancellation or offer to renegotiate terminates the inspection period. So buyer signs a cancellation agreement, says they want their earnest deposit back on that cancellation agreement, and sends it to the seller. Our inspection period is now over and done with, regardless of whether that's the 5th day of that 10 days or the 2nd day of that 10 days or the 10th day of the 10 days. Inspection period is over and done with. Same thing applies if they send an offer to renegotiate. Send their inspection notice, let the sellers tell the seller, hey, we found some things that we're not happy with, but if you agree to fix these things, we will continue on with the contract. Offer to renegotiate. Once that request is sent, also terminates our inspection period. So the resolution of unacceptable conditions is the form that we use to ask the seller to either, number one, make any repairs or give financial consideration, financial renegotiation instead of doing repairs, which is always one of the better things to do, but we'll talk about that at a different time. Upon receiving that resolution of unacceptable conditions, the seller has the right to accept that, it's because it's an offer, accept that, reject it, or reject it and make a counter offer, because that really is an offer being made. Then we're saying here, any of the following executed and delivered to the other party within hour. Oh, I guess I skipped over this too. Once that request has been sent to the seller, we now open a whole new time frame, which is known as our inspection negotiation renegotiation period. Our default in here is 5 days. You might want to extend that, but we'll talk about that on Wednesday. At the time that, so then a whole new time frame here. So, and again, the seller had those three options when the seller's being made. Within that time frame, one of these three things on line 557 through 564 has to have been done. The seller's signature agreeing to do everything requested by the buyer on that resolution that the buyer sent over. Number two, a revised resolution of unacceptable conditions that's signed by the seller and then presented to the buyer that the buyer signs. Or the buyer's signature on the resolution of unacceptable conditions, accepting the property in its present condition. There are times, and we'll talk about that at a future time too, buyer can change their mind after sending that resolution and say, as long as they do it within that 5-day renegotiation period, and say, never mind, I changed my mind, I'll accept it as it is. Kristen calls it the just kidding box. I could call it I changed my mind box. So, all right. If no agreement resolving the unacceptable conditions is reached during that 5-day renegotiation period, we have these two options. Negotiations may still proceed. Any agreement must be in a written amendment and signed by both parties, or either party may cancel the contract. Again, unilaterally, and the earnest money becomes subject to the earnest money paragraph that we're going to get to here pretty soon. I never have enough time in this 2-hour period. I always spend too much time on other things. So, all right. So either party may cancel, so unilaterally send the cancellation notice. Defaults and remedies. If the seller defaults on their obligations in the contract, the buyer has two options. The buyer can take the seller to court, that's on line 586, and ask the judge to make the seller sell the house. And yes, absolutely, that does happen. Or the buyer can terminate the contract by written notice to the seller, and at buyer's option, pursue any remedy or damages available by law. Or if buyer elects to terminate, the earnest money becomes subject to the provisions later on. So the buyer can sue for specific performance or terminate the contract and expect to get their earnest deposit back if it's the seller that defaults. If it's the buyer that defaults, the seller has an additional right, but also the seller can specifically enforce the contract by going to court and asking the judge to force the buyer to buy. The seller can cancel the contract, release the buyer of their obligations, and give the earnest money back to the buyer at the seller's discretion. Or if, because and I should have said the other one first because I do confuse myself here. Seller can release the buyer from the buyer's obligations, but the seller says, but I'm keeping your earnest money, because after all, that was the whole point of the earnest money. If the seller keeps their earnest money, we call that the liquidated damages, and the seller's really giving up their right to sue for any other damages, financial damages. If the seller does not retain the earnest money, then the seller can sue for actual damages in court. So one other option that the buyer doesn't really have there, that the seller might have if there's dispute resolution here, this paragraph actually says that both parties agree to go to mediation before going to court. Of course, we can't enforce that, but it is at least putting that idea in their head. And if you have a buyer or seller that's wanting to take the other party to court, you might remind them, well, we've got mediation available. It's cheaper, but they might not go for that, even though they've agreed to here. So paragraph number 16, radon, microbials, and other environmental pollutants. This is our disclosure to the parties, specifically the buyer, that radon can be tested for. It's a carcinogen. It's a known carcinogen, known health hazard. It can be tested for, fairly easy to remediate, but then they can also test for mold, air quality, any other environmental pollutants. The lead-based paint disclosure tells us here that that's a required document. Criminal offenders, Kansas and Missouri both have places that a buyer can access to let them know any registered sex offenders living in the area. Access that information. It is not up to you to make that disclosure. It is up to you to direct them to the websites. But you cannot say, even if you're pretty sure that there is one down the street. Franchise disclosure, this letting all parties know that if they have a problem with a franchisee, such as Keller Williams, that the franchisor, Keller Williams International, is not responsible for the independent broker's actions. Paragraph number 20, this is our required brokerage relationship disclosure. I'm not going to go through the whole thing. It is your responsibility to make the disclosure who's being represented by whom. 99% of the time, if you are selling a property that you found at MLS, you're going to see what the listing agent's capacity is, and you're going to mark that on here on line 697 on the left-hand side. Most of the time it's going to be that they're designated seller's agent. It could also be that they are a transaction broker or a seller's agent. So make sure you're looking at that. We'll talk about that on Wednesday. And then you though, however, will always be the designated buyer's agent, as long as you have an agency agreement with that buyer. Most of the time, that's how you're going to fill it out. If you are not representing the buyer, come talk to me. If you are selling an unrepresented seller listing, like a for sale by owner, come talk to me, because those are all special. Most of the time on line 717, our disclosure here is who is paying who, and brokers are compensated by, and most of the time it's going to be sellers and buyers both. Everybody signs this page. You will sign this page if you're assisting the buyer. All buyers sign this, all sellers sign it, and if they're working with another agent, their agent signs it too. Paragraph 21 is about the earnest money and additional deposits. As you learned back in your pre-license class, the earnest money has to be deposited within certain periods of time, depending on where the property is located. This is that disclosure here. If the two parties cancel the contract, actually our contract says, and let me deal with that before I get there. Our contract says that if the people get to the closing table, the money will be released back to the buyer. Both parties have signed off on that by signing the contract. If, however, one party or the other cancels the contract and there is a dispute as to what happens to the earnest money now, you learned back in your pre-license class, the two states have kind of different rules about that. But if we don't have any resolution between the two parties, the money cannot be dispersed. It's going to be held for 1 year in Missouri, for 5 years in Kansas. We have lots and lots and lots of money being held in dispute in the escrow account here. But that whole paragraph is all about that. Paragraph number 22 is about the taxes, prorations, and special assessments. Our title companies do the very best they can to accurately prorate those prorated items. But this paragraph says, buyers and sellers, you can't come back to the title company. They did their very best. Don't come back to them if there is a discrepancy between what they prorated and what the actual cost was. Sometimes we can't determine the actual cost. Paragraph number 23, obligates the seller here. This is what the seller is agreeing to do. Seller agrees to sell and buyer agrees to buy. That's our consideration for the contract. But what the seller is agreeing to do here is to provide a preliminary title report that shows marketable title. And they will provide the title insurance. They will pay for it. Paragraph number 23 is all about proving marketable title, and the seller will pay for the title insurance. Paragraph number 24 is our expiration. Of course, we can put an expiration in any of our offers. This allows for 5 days, which is way too much. I wouldn't put more than 24, 48 hours. Another one of your obligations is to completely fill in all of the information about the two brokerages involved, if there are two. You're filling in on the buyer side, your information, and KW and KC Metro's information. If you're working with a co-op agent, you put their information in there too. And then the last thing, once your buyers have signed it and it comes back to you, before you send it on to the listing agent, you will be signing line 880 down here, attesting to the fact that no one has made any changes to the pre-printed contract. All right, that's it. I'm only 3 minutes over time. All right, so I'm going to cancel. I'm going to stop share here. Nobody else joined me. Oh, before everybody leaves though, I'm going to hold this up for Jody and Amber. Your QR code here for check-in for the class.
Okay, thank you.
This is one of those required classes. Did you get it too from up there, Anna? Okay. Did you get it also? All right. See, everybody's
All right,
smarter than me.
cool.
Okay, so this is one of those classes that we require you come to before you graduate launch. This one, the second one I'm going to be teaching on Wednesday. There are no other classes from me on contracts classes because of the holiday. I can't remember when you all are actually finishing up your classes for. And then the month of December gets kind of weird too. I'm not sure that I'll be teaching any contracts classes in December, just because we tend to kind of cut everything off about the 15th, and I'm teaching the first 2 weeks of December, I think. So there's all of that. Everybody check in. Let me know if you have any questions. Everyone here now has my phone number. Anna, did you get my
Yep.
phone number? Have you and I texted back and forth? Okay, go ahead and send
I-
me a quick text just so I'm connected with you. Everybody reach out to me. You know, my email address, contractscoach@KWNKC. Metro, Jody's telling me has a question.
Yeah,
Okay.
can you hear me at all?
Nope, I can't hear you.
Okay.
Jody, either text me or put it in the chats here.
Thanks, Linda.
He's texting me. I guess it on my phone, so I don't hear it. Otherwise, I will see you all Wednesday.
Cool.
Everybody,
you.
thank you.
No,
Everybody have a great week.
You too.
You too.
Thank you so much.
Thank you. Thanks for being here, Daniel.
Yeah.